What is competition law? Well, it's essentially a set of legal tools designed to control the exercise of market power, which is the ability to raise prices above the competitive price, reducing output, creating artificial scarcity. You have commentators who argue we should be using competition law very aggressively to regulate, to tackle the sorts of market problems, the sorts of market dominance that has been associated with the digital economy, with the technological disruption that accompanies it. Most systems of competition law have three key strands by which to regulate the acquisition and the exercise of market power. First, you have rules against anti-competitive agreements. In the EU, this is regulated by the Treaty on the Functioning of the European Union, TFEU. In the US, it's regulated by the Sherman Act. Under both Article 101 and Section 1, there are two core elements. You need to demonstrate some form of agreement between two independent firms, and you need to show that that agreement has an anti-competitive object or effect. In some instances, the anti-competitive object is very obvious, so a price-fixing cartel between competitors in a market. But in some instances, it might be more ambiguous. It's not entirely clear whether the arrangement, which might restrict a dimension of competition, in fact harms competition overall. Our second key strand of competition law are rules regulating anti-competitive unilateral conduct by undertakings already holding significant market power, what's called abusive dominance under Article 102 TFEU, and what's called monopolization under Section 2 of the Sherman Act in the US. Again, there are two key elements to this prohibition. You need to demonstrate that the undertaking, the firm concerned, already has a position of significant market power. They already are able to act independently of competitive constraints. The number one indicator of market power is market share. EU law, a market share of 50% or more gives a presumption of dominance, but in fact most of the cases the European Commission takes involve undertakings with much higher market shares. The second element is that we also need to demonstrate that the undertaking has abused their dominance. They've engaged in some form of illegitimate behaviour on the market. Dominance as such is not prohibited. That would be a completely unwieldy rule. It would be very counterproductive to prevent firms from gaining dominance, but we certainly want to prevent them from abusing that dominance. And this is where, in the context of the digital economy, most of the interesting questions arise, because we're typically dealing with new business models, new business practices. The question we as competition lawyers ask is, to what extent should we approximate this very novel type of business behaviour to one of the existing categories of abuses, or should we find a new theory of harm? Should we find this new anti-competitive behaviour to be contrary to the established Article 102 prohibition? Finally, we have merger control, and in both the EU and the US, it's a pre-notification regime, which means you need to notify your proposed transaction and have it approved by the competition authority before the merger can go ahead. We're only really talking about the very largest mergers when it comes to merger control at an EU and US level, but the idea is that these transactions should not be permitted to proceed if they are likely to significantly impede competition going forward, or substantially impede competition in a relevant market in future. The difficulty when it comes to the digital economy is that very often one of the firms involved in the transaction, the firm being acquired, is at quite an early stage of development. It's not making much money. It's not even clear that the business model is going to be successful. And so the question we as competition lawyers and competition policy experts have to ask is, to what extent should competition authorities be second-guessing the likely performance of that firm, the likely evolution of the relevant market, and prohibiting transactions before it's clear that there's really a competition problem?